Intellectual property is not just a business issue, it's a financing issue as well. As I mentioned last month, one of my portfolio companies, Centera, a drone analytics business, recently closed on a $14 million transaction, and their intellectual property portfolio was part of their getting that funding. Also, for those of you who may have attended, I did a financing options session back in late August. And you might remember that one of the items that I covered there was intellectual property secured debt. So a form of non-dilutive debt financing secured by the IP portfolio. These are just two quick examples of the power of intellectual property. Before we get to today's talk, I'd like to thank our sponsors, Schwegman, Lundberg, Woosner, an intellectual property law firm. And our speakers, Dave and Dave, will be joining us in a bit. Olson Thielen CPAs, a full-service accounting firm, and Tony Ullman is right up here to my right. Tony also will be chiming in a moment about valuations and how that fits into intellectual property. Irish Titan is a web development and e-commerce firm. I have Darren Lynch in the back to my left, and I have Megan Duran over here to my right on the right side of the room. Sunbelt Business Brokers is an M&A advisory firm. McLeod and Company is a holistic marketing agency. And in the back, I have Sam Stender. Thanks, Sam. And they do, McLeod, that is, does a lot of work for Club E as well as my portfolio companies. And I suppose I might as well just run right down the list. So does Irish Titan, and so does Olson Thielen, and so does Schwegman, Lundberg, Woosner. And that leads to Highland Bank, a local family-owned community bank with about $530 million in assets. And Angie Truckee is over here to my left. Also mention that I now am on the board at Highland Bank. So thank you, Highland Bank, for having me on your board, as well as supporting Club E. And then last but not least is the Network Connect, which is a catalytic gateway for connecting investors, companies, and service providers. I do that work with Dick Summerstead. And where's Johnny? Johnny over here to my left. And while I'm talking about the Network Connect, you have these handouts on your page about the Lessons from the Garage library. It's a series of video podcasts with about 200 titles so far, and the library is growing by the week. If you like events like today's, you'll find, as I mentioned, at this point over 200, and we'll be in the mid-200s in the not-too-distant future. Again, there's a handout on your table to tell you more. I also have a card with a discount code if you want to do a trial. And think of this as kind of like a Netflix for entrepreneurs and business owners who are trying to grow their companies a little bit faster. All right, so that's the Network Connect and our sponsors. So again, thank you all for supporting Club E. Reminder to RSVP online through Brown Paper Ticket. It's generally the first Thursday of the month, although sometimes there are other events. And Sam Stender was nice enough to create a little calendar of events here you can take with you. And you can find more information on clube.com as to what events are happening in the future. There's also a LinkedIn group, Club Entrepreneur-Minneapolis, with about 2,700 of our Club E friends and family. And there's a meetup group as well with about 2,000 folks there. An email list that you can either sign up for on clube.com or give me your card and I will add you to that. Minneapolis Club, I mentioned, has been a sponsor of this series. We've been doing it since 2007. And if you'd like to learn more about the Minneapolis Club, please let me know. We started with McLeod doing a Business of the Month about a year ago-ish or so. And Gap Works is this month's Business of the Month. Gap Works is an advisory practice that solves companies' customer-facing challenges, and so they help employees of companies create and retain more customers. To be the Club E Business of the Month, you drop your business card in the fishbowl out in the front when you're leaving. We draw one out, and then the Business of the Month gets put into the Club E social channels. So it's quite a good deal, given that you don't have to pay, and yet your company gets visibility. And thank you again to McLeod for making that happen. Again, I mentioned the upcoming events on the sheet on your table. Just real quickly, October 11th is an owners forum. October 17th is Club E St. Paul, and Chum Struve is off to my right, who runs that. October 22nd, we're doing a growth challenge here with a couple of companies with Upsize Magazine. And then again, last but not least, November 1st, Jeremy over here to my left up at this front table is going to be talking about how business owners can measure and mitigate growing cyber risk on November 1st. Tony Oman is the business valuation manager at Olson Thielen. Come on up, Tony. Tony's focus is on valuations, and I thought as kind of a starting point for today's conversation, I have Tony just say a few words about valuations and intellectual property. So Tony, come on up.
Thanks, Rick. Can everybody hear me? So I just thought it'd be helpful to kind of offer my 2 cents in this discussion. When we're talking about IP from a valuation context and a business valuation context, it's often sort of 2 sides to the same coin. I was looking at a study recently by Ernst & Young, and if you looked in the 1970s and you said, how much of corporate value is made up by tangible assets? It's roughly 80%. Today, that ratio is flipped. It's less than 20% of corporate value is intangible. So intellectual capital, intellectual property. What that's created is a demand for valuation services in an IP context. And I guess what I wouldn't be doing my job if I didn't remind everyone that, I think from a valuation context with IP, there's always the compliance reasons. So I think owners and business owners have to understand there's financial reporting reasons why IP would have to be valued. There's tax reasons. But I think what can be a missed opportunity, or at least from my perspective, a more value-added discussion is really thinking about the value of IP from enhancing overall business value. We see it a lot, and I think even Rick maybe mentioned it in some of his companies, being able to transfer that value and really assessing what that value really is in a transaction is something we see and we think adds a lot of value to our clients. So that's really all I had to say. I think, if there are any questions or comments more from a valuation aspect, I'm here to help, and I'd be happy to help any way I can. Yeah?
I have a question. When you are the seller, I totally get you want to put as much value into that intellectual property as possible.
Yeah.
When you're the buyer, how do you discount it?
Well, it depends. Okay, that's probably a long answer, and feel free to cut me off.
I would say if that is a long
Okay.
answer,
Yeah.
then maybe give us like the one sentence, wrap it up in a bow, and then see Ward afterwards.
It depends on if it's real and transferable. So, one thing I hope to learn is kind of from the Dave, sort of that legal technical protection on it. Also, it depends on how many buyers I have. Do I have to pay them for that value? If I'm one buyer, I have leverage in that transaction. If I'm a seller and I have multiple buyers, I'm going to have to give up value and credit for that. So I think that's a very, very simplified answer, but it's a very good question. Yeah. Thanks, Rick. Yeah.
Good question, Ward. The intention of introducing Tony to the conversation with valuations and IP, little different angle, topic that maybe we'll cover a different day, but I wanted everybody to okay, that is part of the discussion. Wanted to introduce Tony as somebody that could help folks out. So again, please feel free to see Tony afterwards. All right, Dave and Dave, why don't you come on up? So our fireside, come on, either way. The concept here was like fireside chat, so it's more their conversation, not me leading it. They would like you all to participate. So again, if you brought questions, please feel free to chime into their conversation. And then the other aspect of our fireside chat and the Dave and Dave show was that they've worked together for a lot of years and have great rapport between the two of them. Dave Black, to my immediate left, is both a patent attorney and principal at Schwegman Lumber Woosner, has been there for over 20 years. Dave Black, immediate left here, would be the patent person. And then Dave DiZarilla on the far left, also patent attorney and principal at Schwegman and has been practicing IP law for over 25 years. Dave DiZarilla does more of what I call the soft side of patents. And so they are here to talk both about trademark, copyright, softer side of patents, as well as the actual patents with Dave Black here. I'm going to turn it over to them and let them run with it. And again, this is an opportunity for folks to ask their questions and not be on the clock. We're not going to be billed for this today, are we? No? Okay, so it's an opportunity to ask a lawyer a question and not get billed. So again, if you have stuff that comes up, please raise your hand. Otherwise, I'm going to turn it over to you guys and let you roll.
Thanks, Rick. Hi, Dave.
How's it going, Dave?
Not too bad. So we heard a question here just a little bit ago. Wade was asking about valuation and from the buyer's perspective in terms of thinking about intellectual property and what factors might influence the genuine value from the buyer's perspective. And it occurs to me there's all different kinds of flaws or shortcomings that you might be finding in intellectual property, different specimens, for example, that may be used as leverage for from a buyer's perspective. So we know that we have intellectual property in the form of patents and trademarks and trade secrets and other aspects as well. What kind of things would you think of with regard to what would impair the value of a patent item or a patent portfolio?
Well, I think the first thing you have to do as a buyer is to make sure that the person, claiming to be the owner of that patent or trademark or copyright is the owner. And I was talking with one of you before the lunch, and sometimes, like for example, with a trademark, especially with a startup, you may have a single person who started the company, then acquired, then incorporated, then has a few employees, and now is going to exercise his exit strategy and sell the company and get his payday. Well, if the company has built up some goodwill in their mark, and that's part of the sale. In fact, maybe big part of the sale. Maybe that owner, the original CEO, didn't register the mark. Okay, and so it's not clear maybe who owns it, the goodwill that the mark has acquired, or if he or she did register it, then perhaps he or she registered it in their own name and not the corporate name. Because either they didn't think about it when they registered or the corporation didn't exist at that point in time. So if you go through the deal as the buyer and you think you're buying the mark, but the corporation doesn't have the rights to the mark, they can't sell you that mark. So that's one thing you want to do. You want to make sure the entity claiming to be the owner is the owner, or else the value is obviously much decreased.
So that's a pretty important consideration from the standpoint that the whole notion with much of the intellectual property landscape we're talking about is exclusivity, is the ability to control access to that technology or to that mark, whatever it might be, that the form of intellectual property. And so ownership is so critical, and we use instruments to convey ownership from one entity to the next. And if you have diluted ownership in the form of multiple parties that have unfettered access to that intellectual property, can really impair the value, wouldn't you say?
Yes. And the other thing that came to mind regarding this buyer question is that you want to perhaps check about the foreign rights or the foreign ownership in different countries. For patents and trademarks and pretty much all IP, ownership is territorial. That means if you have a patent in the U.S., it's enforceable in the U.S., but it's not enforceable in Canada. It's not enforceable in Mexico. So if the person with the technology, the patent, has the U.S. patent, but they either don't have the foreign rights, or they've foregone the foreign rights, or they're in the priority period of 1 year to attain foreign rights, but they've publicly disclosed their invention before they file the U.S. patent and don't have absolute novelty, then they've foregone their foreign rights. So from the buyer's standpoint, then the IP is not as valuable because the the owner did not take the steps in the proper order to secure all the rights that they were entitled to.
So maybe we should review just a little bit here and talk about the different types of intellectual property. So one, of course, is a patent, and a patent is a right bestowed by a governmental, by the United States government or whatever other jurisdiction that you happen to be filing in. It's a territorial right. It has boundaries and limits to the scope that it can reach in terms of what activities or what products are brought to the marketplace, or what people can practice or implement or build. And a patent, of course, is one of the first fundamental intellectual property rights that we might be thinking about. And there are a number of critical questions that have to be answered in order for you to qualify to receive a patent. And so it's an application process. You have to come before this tribunal, this governmental body, the Patent and Trademark Office in this instance, and you have to have established that your innovation, your clever idea, is sufficiently new. That was the word novelty that we heard from David just a moment ago. It has to be new. It has to be sufficiently clever. We think in terms of obviousness. Is this something that we would have figured out even if you hadn't come along with your clever idea? But it has to be sufficiently clever. Another important consideration is you have to disclose and share with the public in the form of your application all of the clever bits that go into your invention, and make sure that you share this, because this is a bargain with the U.S. government or whatever other governmental body, if you will, that you're saying, I will share with you all of the clever elements that go into this. In exchange, I enjoy some limited right of exclusivity for a period of time. 20 years is the nominal unit. And so what it amounts to is it's a bargain. And the idea with it is to promote others to read these documents, learn about it, and then stand on your shoulders and develop the next generation of clever ideas. So that's what a patent is all about. Other important types of Mara's got a question. Hey, Mara. Oh, there certainly are limits on what you can get a patent for.
Yeah, I was just going to actually stand on Dave's shoulders here.
Yeah, go ahead and step there.
Use his knowledge, but patents are basically for technology inventions. It's called patentable subject matter. The statute says it's for processes, compositions, manufacturers, and machines, I believe. So patents are for inventions. So if you have a work of authorship like a play or a book or a song, that's not an invention, that's a work of authorship, and that's more the copyright domain. Although there's some overlap between the two. For example, software. I mean, that's a work of authorship, but it's also a process. So you can get both areas of protection, and one has advantages over the other. So it's got to be patentable subject matter, and it basically has to be an invention or technology.
So there seems to be some struggle in the law with regard to what are the sorts of clever ideas for which we will grant a patent. And so there's your springboard.
That is correct. Are you talking Alice?
Yes.
Okay. I didn't know if we wanted to get into that. It's kind of
just very, very briefly.
That's kind of the weeds of patent law for the geeks like me. But that's why he threw me that question. But in June of 2014, the Supreme Court came down with the decision, Alice v. CLS, and dealt with patentable subject matter, and it was a computer programmer system that was patented and was directed towards this concept of intermediated settlement, where you have a intermediary that has parties on both sides, and he or she makes sure, actually not he or she, but the system, the computer made sure that both sides did what they had to do before the deal was done, and it was written as a computer system did this. And before that, there was a lot of, and there still is a lot of debate about, can software be patented? And that debate's still out there. But basically, in short, that this decision kind of cut back a little on software patenting and maybe business method patenting. It didn't do away with it, but it was kind of a hit on patentable subject matter in that area. Now, recently the patent office has, you know, kind of swung the pendulum back a little towards more protectability, and they've gotten a little more lenient in their interpretation of this Alice case. And so it's swung back a little, and I think it's going to swing back some more. But it's an ongoing process now, and it'll be interesting to see where it ends up in the next 2 or 3 or 4 years.
Yeah, we've got a new director at the United States Patent and Trademark Office, and he's signaled that there's going to be some more flexibility with regard to some of the tests, that the questions that get asked in terms of, is the application in front of me the sort of thing for which we want to give a patent? And so we have optimism that that more often than not we'll get favorable answers to that important question. Because otherwise, clients are, you know, it's difficult to adequately protect software innovations, and some of the greatest innovations are yet to be made in some of these areas, including artificial intelligence, implementation of those routines. Now, you're probably not going to get a patent for a clever way to take a pizza order on the telephone with a notepad. That's not the sort of thing our patent system is designed to reward, and so we want to incentivize the right things.
Can you speak to apps? Is that copyright or is that patent when you have an app?
Yeah, an app, I mean, app, you know, from an IP standpoint, is basically still software. So it can be either. But so to get into that area a little more, I mean, copyright protects the work of authorship, the actual photograph, the actual sculpture, the actual text of the play, of the book, of the novel, of the
So the specific lines of text for the code that implements that function.
Right, and it protects the expression of that. Okay, but it doesn't go to if it's, of course, there's not a process in a novel, but for software there's a process that is implemented and executed. So the copyright protects the expression of that code, but it doesn't go to the process. So if you just copyright your software, someone else can look at your software, see what it does, and pretty much write their own, as long as they don't copy yours. Okay? But if you then patented that technology, and you would not patent the literal expression per se, but the process or the technology that software does, then you prevent someone else from doing that same process, even if they write their own code from scratch. So that's kind of the difference between protection of software by copyright, the expression thereof, and protection of the technology underlying the software, the patenting thereof.
So we make a distinction with regard to copyright. We talk about the idea or the expression. And in copyright, in the realm of copyright, we provide protection for the expression, not the idea. And when it comes to a patented innovation, something that's worthy of a patent that meets the requirements, we really are getting to the concept. And we need to, as part of the application process, we need to also set forth specific examples of how that could be implemented. But in terms of the concept that surrounds that innovation, we're really getting to that with regard to the patent protection. Does that make sense?
Sort of. Yeah. Yes. It's a little blurry.
We can talk afterwards if you like.
Yes, is that a U.S. software patent foregoing the international patents? And that international company, is in violation of your patent if they have U.S. customers, U.S. clients using it. Is there any way to resolve that if you go after the IP for what that
Well, I mean, if the invention is being practiced here in the U.S. by U.S. customers, that's taking place in the U.S., that's a violation of that U.S. patent, notwithstanding that they're a foreign company. So, and infringement of a patent, it involves either, making the invention, selling someone else's invention, offering to sell someone else's invention, importing that invention, and there's even provisions in the infringement part of the patent statute regarding making some components of the invention here, sending it overseas and assembling it overseas. And there are a lot of factors that go into that decision. Well, is that an infringement or not? But it's basically, it's where the invention is sold, used, offered for sale, or made. And so it doesn't matter if the brains behind the quote-unquote infringement is a foreign company. If it's being done here in the U.S., that's an infringement of the U.S. patent.
So this also circles back to some of Wade's question earlier with regard to evaluation from the buyer's perspective in terms of a patent or a patent portfolio, from the standpoint that an important part of a patent includes what are known as claims. And the claims set out the boundary of the innovation in terms of, and that's part of the work that the work that a patent attorney is charged with in terms of trying to figure out, how do we define this concept? What is inside the fence and what is outside the fence? And so this is a line drawing exercise, and it includes writing what are known as claims. And these claims are very specific sentences that lay out the boundaries, using words and the challenges that come with that, of course. And then an interesting aspect is, we were talking about an infringement situation. Well, you also have to read the claims and interpret those claims and think about what that foreign company is doing and try to figure out if it infringes or if it's within or without the fence line of one of those specific claims. And so one way to evaluate a patent portfolio or a patent is to look at the claims and say, who is this thing targeting? Okay, is this targeting my customers, a manufacturer, a distributor, or somebody who repackaged an ISP, or who is the infringer here? And so we have to read the claims and think about what it has to say in terms of identifying who is that target party. And that too plays an important role in terms of thinking about the valuation, because few of us want to go after and sue our individual customers. We'd rather go after a competitor. What do you have to add to that?
The other thing I would add is in an infringement analysis, you infringe one of these claims that David just spoke of by practicing or containing or making a product that contains each element of this claim. So if your claim has 4 elements, A, B, C, D, then you infringe that patent by making or practicing A, B, C, D. You don't infringe it if you only do A, B, C. If you're not doing D, you don't infringe. If you add a step or an element to this claim or this patent and you do A, B, C, D, E, you've added E, you're still infringing, because the question is not what you've added, it's do you do A, B, C, D. So that's what infringement is and is not. And but if you do A, B, C, D, and E, and adding E is novel and non-obvious, you can get your own patent on that. But we have what we call a blocking patent on A, B, C, D, and then you have to practice your patent. You have to get a license from the owner of A, B, C, D.
So we better figure out who has that ownership in that product we're going to license.
Correct. And so, I mean, the bottom line here is, just because you get a patent gives you the right to exclude. It gives you the right to prevent others from doing A, B, C, D. If it doesn't give you the right to practice A, B, C, D, if there's a prior patent even before that on A, B, C, then you've got a blocking patent on that one. And this is what David spoke about earlier about encouraging further invention. And this is when you get into the area of cross-licensing. You may have heard that term before, and dominating patents and other issues in the IP field, especially the patent field.
So that's a pretty important point about the rights of a patent convey exclusionary rights. It allows you to stop somebody. It tells them, so if you think of the real estate analogy, if your neighbor sets up a picnic in the backyard at your place and your patent covers the backyard territory, you can ask them to move it across the fence. But it does not give you the right to do anything you want. For example, you'd likely be precluded from deciding one afternoon that you'd like to put up a 7-unit or 7-story apartment building in your backyard. You don't have that ability, even though you own the property. We had a question here and one in the back. But let's go here first.
I'm wondering if that the ABCD, someone else does ABCD, is that, and that's an infringement, does that model or modality apply to trademarks as well the same way?
No, it doesn't. Trademark is completely different. As we said, patents protect technology and invention. Trademarks are just what we call any symbol, device, word,
Or
et
a
cetera,
smell.
or taste, or whatever. But those are or color. Those are a little less frequent. But basically, any word or logo or symbol. And the purpose of a patent was to protect an invention. The purpose of a trademark is to identify the source of goods or services. So if you like a certain burger and you drive by on the highway and you see these golden arches and you say, oh, I like that restaurant, I want to go to it, I know where they stand behind their product, I like their product, I'm going to patronize that business. Or you can say, I've been there before and I don't want to go there. So to answer your question, you infringe a mark by having a mark that's identical or too close to someone else, which in the same channel of trade or the same goods and services. So that's important in trademarks, is that a trademark doesn't exist in isolation. It's associated with the goodwill of the source of the goods and services and also what those goods and services are. So that's why we can have marks that are identical but peacefully coexist in this U.S. economy. For example, we have a Delta, which is an airline. We have a Delta, which is a faucet company, and we have a Delta, which is a dental insurance company.
And my dog is named Delta.
That's true too, but that's not a use of a trademark. But we won't go there, okay? So, but anyway, so that's just illustrates the two-pronged approach of trademarks: the mark and the goods and services, and the goodwill that attaches to that mark.
So going back to the ABCD, this is too deep in the weeds. I'll take it offline, but if the patent is claiming ABCD, which leads to an outcome, called Q, by the process which uses EBC, is that an infringement?
No, as long as the outcome is as long as the outcome is not part of the claim, and the patent is ABCD, and you only do ABC, and you get the same result, it's not infringement. Would you agree with that, David?
Yeah, no, I think that's right, and we encourage that. I mean, we can, we there are many different ways. I can go from here in Minneapolis to Chicago, and some of those pathways may be infringing if we had a recipe that laid out the route or the mode of transportation, if you will. In other ways, it would be completely outside of the scope. And so we reward that. That's what our system does. Our patent system rewards innovation for finding new ways to do something and achieve a result. But as David was saying, if that outcome is a recitation in the claim, and there are certain magical phrases that get used to describe one of those elements, for example, it could be part of an infringing act. So we'd have to look at the claim. That's what it amounts to.
And to add on just one more point is that when you have a claim ABCD, assuming there's no AB out there or ABC, and you could have written your patents that it wasn't directed to ABCD but only to ABC, so your patent is actually broader by removing an element. That's the way it should have been written. So that would be a pretty offensive mistake if it was written too narrowly and was easily avoidable by just saying, oh, well, we can get to the same result by just doing ABC, and they've claimed ABCD.
So that might impair the value of that product again, that patent. So if the claims recite needless elements, that's an inferior, a sign of an inferior kind of an application or a patent. Was there another question at this table? Yeah.
If a person has a smaller company, and maybe they have a name that's the same or similar to a bigger company, maybe there's another name like the Delta Company. But where's the line between similar names and similar trademarks, and how do you draw the line between sub-industries? So if one named entity, or law firm, or something else, do they have protection in those silos? And what is the line there? Can you rephrase the question for the sake of the video?
Oh, sure, sorry. The question is, I guess, pretty much how do you determine how close you can get to a prior mark, and how do you determine if you're infringing on someone's trademark? And that's the question that keeps litigators in business. I mean, to take your example, you said a smaller company and there was a larger company that had a mark. I mean, the best answer is to pick a mark that is clearly different than them. I mean, so they have no action against you at all. That's what a good businessman would try to do, or a good businesswoman would try to do. That's easy to do when you have known marks out there. If there's another mark out there that you're not aware of or you didn't find in your search, then and it pops up later on, that's an issue, and that's, like I said, that's what lawsuits are made out of. But in general, I mean, there's no black and white line. Here's the line, and if you have a mark and then you put a plural on it, you pluralize it, it's still an infringement. That's probably true. But if you change it a little more, and a little more and a little more, you have to look at the facts of the case and decide there. But basically, I advise my clients, if you know of a mark and you're really in love with that mark, but someone else has it, well, that's unfortunate. It'd be best if you just kind of go back to the drawing board and pick another mark which will not cause you any headaches in another year or two.
Yeah, if you're never going to make any money at the business, then nobody cares and nobody's going to sue you. But as soon as you start making money and become profitable, they'll take notice of you, and then they'll become interested. So and these are one of these questions. I mean, if you can avoid it at the front end, otherwise you're going to spend $500,000 to litigate it later on and try to figure out, was I too close or not?
Real quick about trademark copyright. We happen to do curriculum in K-12 schools. Mm-hmm. So we're always struggling with, okay, we have a brand new product, curriculum, it's got a logo, it's got a script, it's got all the written materials. And how much are we protected by just first use versus having to go through the process of trademark and or copyright, and where is that risk reward happen? Because there is an expense for getting to copyright versus just first use, and I know
Right. Well, I mean, with copyright and trademark, you don't have to register them either way. I mean, for trademarks, you get protection in that mark as soon as you start using that mark in connection with selling goods or providing services. I mean, so trademark rights are established through their use vis-a-vis the common law. By registering it, you get definite benefits. We get things called nationwide effect, meaning it's good throughout the country. You're on the Federal Register, which if someone else wants to register a mark that's too close to yours and they see your mark, they shy away from it, hopefully, if they're a reasonable business person. You get to use the Circle R symbol, which puts some meat behind it. People say, oh, this is federally registered, and that's important. Similarly with a copyright, your rights in your work of authorship vest as soon as it's put into a fixed medium, whether it be on paper, disc, on the canvas for a painting, and on the stone for a sculpture. So you get your rights as soon as it's expressed in a tangible medium. But to register it, you get additional benefits, such as being able to go into federal court and enforce your copyright against others. And being not being apprised, but having the rights of the International Berne Convention applicable to your copyright. So, I mean, once again, there are benefits to registration of both copyrights and trademarks, and I understand that it's not free, but I always tell my clients that trademarks and copyright registration, it's a pretty good deal. I mean, you can register a copyright, if you do it yourself. I mean, the government fee is very, very small, and you get a lot of benefits from that. Similarly with trademarks. To get a patent, I mean, if you employ a patent attorney, it can run into thousands of dollars, and the reason for that is because it takes a lot of work. Whereas if you employ an attorney or a law firm, you can get a trademark for about probably $2,000 to $3,000, and a copyright probably $400 to $500 per work. So it's not free, but I mean the benefits are, I think, worth it, and especially in trademarks, if you're not registered and someone else comes later on and somehow they get a mark that's too close to yours registered, then you have headaches, then you have money, and then it's, I mean, I always tell people, I mean, this is your brand. I mean, this is your source of goods. This identifies you. I mean, isn't your name worth $2,000 to $3,000? I mean, so I mean, that's what some people say. No, I mean, they say no, but I don't think it's a wise answer. But I just in the field of IP, I mean, trademarks and copyrights are, I think, a bargain.
So there are optional steps along the way, but it seems to make great sense to pursue and obtain copyright and trademark protection. And keep in mind too, even a patent is an optional step along the way. You don't have to get one of these. If you want to run a business, you don't need a patent. The thing is though, it does a good number of provides a number of benefits for a patentee, and that's why people pursue patents. But it's not a requirement to be in business.
Yeah, but I think that, I mean, the difference, Dave, between a patent and a trademark registration versus getting a patent is that with the patented technology, if you don't get a protected value patent, you're giving it away.
Yeah, it becomes
giving it away.
You choose to pursue it as a trade secret if that's what you can, if you even have a prayer for that.
Right, but with a trademark, you're not giving anything away. You, like I say, you get rights by using it in connection with your goods and services. Yeah, and it's not registered. If someone else comes later on and starts using a mark too close to you in the same channel of trade, they're still in violation of your non-registered trademark. So you're not giving it away. You've established rights in it.
So I realize every case is different, but if you had to generalize over your 15, 20-year career, I have two questions. One, assuming you've done your research and you believe the thing you're patenting is reasonably different and clever, I'm interested to know what percent of your patent applications get approved versus not approved. And then secondly, how much of the total cost involved with that patent is represented in that initial application and approval versus, legal issues after it's patented? Is it usually half the cost, or is it usually 3x after you file the patent? Again, just kind of broad.
Okay, so in terms of the costs associated with it, and how does it get distributed in terms of the whole overall process? So in the application process, we can think in terms of the United States. You build a patent application. It's a substantial document. Depends on the technology, whether it's going to be very brief or if it's going to be very extensive. And so the application preparation costs are usually quite substantial. They're going to probably entail something on the order of at least a dozen hours, maybe 25 or 30 hours in terms of preparation time to build that document. And then the next step is to say, okay, we submit it to the patent office. The filing fees and such are usually a pretty small portion of the costs in terms of prosecuting an application to grant. Okay, and then you depending on the scope of those claims, how big of a backyard you think you're entitled to, how close is the prior art, how well did you describe it in terms of what's the content in that application. You may be in for an easy ride through the patent office if it's a very narrow scope and you've done a fantastic job of describing it. But on the other hand, if it's a pretty slim description and you're asking for a substantial scope, breadth of your claims, you're going to have a challenge, particularly so if it's in one of these subject areas where the patent office is busy saying, I don't think we want to give a patent for this kind of technology. So it could be across the spectrum in terms of the complexity with regard to where that dividing line is in terms of balancing some of the costs Would you agree?
Oh, yes,
So
that's true.
And then the other question was asking about, you know, the success rates in terms of you file an application, how frequently do you get them allowed, or do they get permanently killed? Well, there's a good variety of different branch points through the patent office in terms of how applications proceed from the start and the entry on the one side of the building to grant on the other side of the building, if you will. And clients have tremendous control over how that process is navigated, what choices are made, what the interaction with the examiner can have a tremendous effect. Market factors influence clients' decision with regard to should we continue with this one or not. Other factors in terms of judicial decisions may impact the choices clients may make with regard to should we keep going or should we stop. There's a good variety of options that remain for a client when faced with challenges coming from the patent office. One of the factors that does, however, play into the calculation is your patent term. So patent terms in the United States are determined largely based on when you filed your application. So there again, we have this dividing line that we can map out, and that dividing line separates the time before grant and the time after grant. And so your exclusivity period does not begin until the time the application has been granted. And so as you get closer and closer to the end point, your value proposition gets tighter, it gets smaller and smaller. So this is another factor that people think about in terms of, will we have success at the end of the day? Will we get a patent? And it depends on the client's motivation and their budgets. So we enjoy, I think, a pretty high rate of success. Our clients generally file only on applications for which they're committed and prepared to go all the way through. So I don't know. What would you say for a percentage in terms of? It's so varied with all these different factors.
Yeah, I think it really depends on the technology area.
That's a big factor as
Yeah,
well.
I mean, like you said, the Alice issues with software-based patents. So it's probably pushed that down a little, but now, like I said, it's probably going back up again. So I really don't have I'm not going to pull a number out of the air just because I don't know. But,
Well,
I would say one thing I would say is that a lot of clients, they don't realize how long it takes sometimes to get a patent, get an application through. I mean, you can file an application and you may not receive a response from the patent office, which we call an office action, your first office action, for maybe 2 years. It may take that long for them to get to your case. And then they get you an office action, you respond to the office action. And then you get another office action, then you get a final one, then you file continuation, then you appeal it. So it can drag out a little. And there are some historical cases where they've been going on for decades, and sometimes on purpose and for not maybe the best reasons. But so the time factor, I think you should be aware of before you get into it for sure.
Yeah, it's like playing a game of chess. There's so many different moves that can be made in terms of the options the clients have, and the rule book with which we work in the United States, at least, is if printed, it's probably a 4-inch thick book. It reads like the federal tax code in terms of how procedures, and how things move through the Patent and Trademark Office. So yeah, there's a lot of different factors that play into the cost calculation.
It's almost one. Why don't we take one more question from the audience, and then I'll give the two of you an opportunity to kind of wrap things up. But again, we can stay here as long as everybody wants to stay. So unfortunately, I think I saw 3 hands over there, so you're going to have to pick up those 3.
Which one?
I didn't see the 3 hands. I'll make an easy job.
I see 3.
Okay, I in the front here. Yeah.
So when a vendor is ready to file their patent and they've done due diligence to analyze the patent, then their patent is currently in review in database that I'm not sure we may or may not have access to. So how do you recommend that exhaustive diligence search is done prior so that there's no patent rejection or who's doing this analysis? Because attorneys may not do such a
Yeah. So you're asking about searching in terms of making an evaluation of patentability at the time of or before the filing of the application, and trying to use that information as part of your calculation for should we pursue this patent application or not. And that too plays into it with regard to the success that we can expect after filing an application and what's the outcome at the end of the day. It's a question you have to answer, as the clients have to answer individually, because the patent office, as part of the filing fee, they collect a fee for the search and examination. And so there's no obligation on the applicant to have first conducted a search before they file their application. However, it's quite prudent to do so because it gives you all sorts of information and helps you tailor your application in the right way. And it might be valuable information. So you have to make a decision. I've got this bag of money. Do I spend half of it on searching before I file my application and the other half on prosecuting, or do I divide it into thirds or quarters? And so that's kind of a client-specific question. We had a client in the office a number of years ago whose philosophy was, our engineers and scientists only come up with new ideas. They are not inventing old ones. So don't waste our money on searching, and so we didn't, but that's a client-specific. What do you have to say?
I'm not aware of that client, but I think the young lady's question was directed to when a patent application is filed by a third party, it's not published for 18 months. So there's this period which is unsearchable. I mean, really. So it's an imperfect system. I mean, that's all I can say. And there's that possibility, but I guess that just has to be involved in your calculus of whether to file or not. And a good resource for that is if you're a company, your engineers and your software engineers, because they kind of have a pretty good feel of what's out there usually. And so and you can do some Google searching for patents and for non-patents, and you can only do the best you can do and then hope for the best.
Okay, so why don't you take a minute each or something and just
Why don't you just
wrap
for
up?
both of us?
Okay, so all I wanted to say is first thanks to Rick and Club E with regard to the opportunity to talk with you folks and think a little bit about intellectual property and how that might play into your business plans. And indeed, we've heard that there are so many different ways that an intellectual property portfolio, whatever it may include, impacts the value of the business. And we're all trying to build businesses here, so it seems quite prudent to deploy the resources and maximize the return. And so we're here to help you if there's any way we can. And if you have other questions, we're always available as well. So thank you, Rick.
Dave, you want to add anything?
No, just whenever you're going into business or considering a new line of business, at least be aware of IP. And Dave and I are usually here for most of these luncheon. If you have questions, come up, talk to us. And as Rick said, we're free in this room. So take advantage of us when we're free, because as soon as we walk out that door, we're not. Okay. But that's and Rick will back me up on that. Okay.
All right, thank you very much. So, reminder, let's see, Chum Struve has her M&A activities luncheon on the 17th over in St. Paul. And then next month here, Jeremy up in the front is going to be talking about measuring and mitigating cyber risk. So thank you for coming. Have a good rest of your week and look forward to seeing you soon. Thank you.